everyone, welcome to the show where we discuss current legal events and legal hot topics from the perspective of a seasoned attorney such as myself. I have practiced law now for over 15 years, and I have practiced as both a litigator and also as a regulatory attorney. Now, the purpose of this show is to provide non-lawyers with a bird's eye view of our legal climate today, and also to provide some insight into the inner workings of the law behind the headlines that we all read. So today we're going to be discussing the case of Dodd versus Jackson Women's Health Organization. And now the headlines relating to this case say Roe v. Wade overruled. If you are pro-choice, then you were probably dismayed by these headlines. And if you are pro-life, then you were probably ecstatic about the headlines. However, I would submit to you that the headlines are not as indicative of the true implications of this case, one way or the other. So today we are going to be discussing the Dodd decision, what it says, and the impact that it might have on our fundamental and constitutional rights, not just abortion rights. But before we do that, let's go ahead and take a look at this quick clip, and when we come back, we'll discuss the case in more detail.
On June 24th, the Supreme Court overturned Roe v. Wade, which granted the constitutional right to an abortion. Since then, the abortion landscape in the United States has dramatically changed, with at least 13 states enforcing bans. The same day Roe v. Wade was overturned, Missouri was the first state to make abortion illegal through a, quote, trigger law. Georgia, Ohio, South Carolina, and Tennessee have enforced 6-week bans. In Kentucky and Florida, they have prohibited abortions after 15 weeks. While some states have been restricting the right to an abortion since Roe's reversal, others have been strengthening it. There are 10 states that have signed executive orders that protect people who have had or performed abortions in their states. Abortion providers in states where access is still available are seeing more out-of-state patients than ever before.
Alright, so as you can see, the country is very divided on this issue of abortion following the overruling of Roe. So approximately half of the states are making it more difficult to obtain an abortion, but the other half of the states are actually staying near what was previously status quo under Roe, or actually making it more easy to obtain an abortion and access abortion care. So that's what I was referring to when I said the implications of Dodd are not everything that they appear to be at first glance. So what does Dodd actually say? So in Dodd, the Supreme Court held that, and I'm going to read this right out of the opinion, the Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Roe and Casey arrogated that authority, and we now overrule those decisions and return that authority to the people and their elected representatives. So now the question is, well, what does that mean? What it means is, just like the map showed, that abortion is now regulated at a state level. And that means every state is able to make its own rules and regulations relating to abortion. And that means that some states are now able to restrict abortion more than it was under Roe, but it also means that some states are able to provide abortion and make it more accessible than it was under Roe. And so that's what I was alluding to when I mentioned earlier that decision is not everything that some people think that it is. Because if you are pro-life and you say, hey, this is great, we can now regulate abortion. Well, that's not anything different than Roe. Abortion was regulated under Roe. The only thing that changed is the manner in which it was regulated. And honestly, Dodd makes it easier for states to regulate it. But in doing so, that means that abortion is likely going to be more accessible in certain states than it was under Roe. And so the question becomes, was this a true victory, or was this what we call a Pyrrhic victory? Somewhat of a false victory. Because if we look at the framework for abortion under Roe, so we are all on the same page, Roe held that there was a constitutional right to abortion in the first trimester of a pregnancy. Under Roe, within that first 3 months of a 9-month pregnancy, women were entitled to seek abortions. However, in the second and third trimesters, the access to abortion was already extremely limited and effectively banned in the third trimester. But for some type of medical issue, abortion was not readily available in the second and third trimester of their pregnancies already under Roe versus Wade and the trimester framework that was devised in that case. The reason why that trimester framework was devised was because Roe held that abortion was constitutionally protected. When a right is constitutionally protected, then courts will usually review that right and any state's attempt to regulate that right under what we call mean scrutiny analysis. And that's just a fancy legal term that means that you have to take into consideration the means that are being used to regulate the right and whether those means are being narrowly tailored in such a manner as to impede upon the right as least as possible. To do that, courts typically use what is referred to as strict scrutiny. So if there's a constitutional right and a state wants to regulate that right, then strict scrutiny will usually apply, which means 1, the state will have to first show that it has a compelling reason for wanting to regulate that right, and 2, the state will then also have to show that even though it has a compelling reason to regulate that right, that it has used the least restrictive means to do so. And so that's where this 3-month trimester framework arose in Roe. Well, let's say in Roe, the Supreme Court found that the state had a compelling reason to regulate abortion. If you're pro-life, you're probably like, oh yeah, that's good. Now, the issue became that to abide by the rule that you narrowly tailor the means, abortion was left open to the choice of women in the first trimester. It was very closely regulated in the second and third trimester. And so that's what all of this abortion issue, if you're not familiar with the case, you probably would think, oh, everyone can just go have an abortion whenever they feel like it, but that's not the case. Roe really limited the ability to the first trimester. And what's now interesting about the case of Dodd is that Dodd says, hey, we're throwing out Roe, and now we are giving the issue over to the states. So now every state can now make their own decision how they're going to regulate abortion. But regulation doesn't just mean prohibition. When you regulate things, regulation has a different meaning from a legal perspective. When you go and get your driver's license, that's a regulation. It's not a stringent regulation, but it's regulation. So saying that a state can regulate an issue doesn't in and of itself mean that the state is going to prohibit it. And honestly, I think a lot of people who are pro-choice tend to think that regulation of abortion means prohibition. And that's not what it means. It simply means that each state can make their own decision. And that's why when we looked at the clip, we saw that some states have actually expanded access to abortion. And for that reason, I would submit that Roe v. Wade is overruled is not everything that it seems at first glance. Furthermore, I would submit that if you are pro-life, this isn't as much of a win as you thought it was, because there's states now that could have abortion in the second trimester or even in the third trimester. Versus under Roe, we knew it was limited only to the first trimester in every single state. Furthermore, there's the implications on other constitutional rights, such as, for example, the right to travel, the right to privacy, and the right to what we refer to as substantive due process. Just for a quick lesson in the law, substantive due process is how we receive most of our constitutional rights. Due process is broken into two areas under the Constitution. Procedural due process, and you have substantive due process. Procedural due process means that you are entitled to notice and a hearing before any constitutional right is impacted. So for example, before someone can take away your rights, that's why you always will receive a notice in the mail. Say for example, you get a ticket, you receive a notice, and then you have a hearing date. And you can go to the hearing, or you can pay the ticket. For example, if it's a speeding ticket. You can pay the ticket and you don't have to go to the hearing, or you can go to the hearing and have your day in court, which is due process of law. Now, that's procedural. There's another aspect to constitutional law, which is substantive due process, which says once you actually get your notice and then you show up to the hearing, from a substantive perspective, how are your constitutional rights actually impacted? So substantive due process says, well, even if you get your notice and your opportunity to respond, did you actually have a substantive opportunity? So for example, without substantive due process, you may have the right to vote from a constitutional perspective, but what impact does your vote have? Without substantive due process, your vote has no meaning, because procedural due process without substantive due process is nothing but form. So form says that you have the right to go and vote. Form says you go in, you check a box, you put your vote in, and you go home, and then your vote is counted. That's all form. Substantive due process, substance says that the government actually abides by the mark that you put on the paper. So without substantive due process, even though you're allowed to go vote, without substantive due process, who you voted for is irrelevant, because as long as the actual vote was held, due process has been given. It's the substantive due process that honestly is just as important as the process, because substantive due process says that the government has to abide by who you actually voted for. So you see how procedural and substantive due process, they go hand in hand, and substantive due process is just as important as procedural due process. One of the things that's most concerning about the Dodd case is that one of the justices actually stated in his concurrence opinion that he doesn't believe very strongly in substantive due process. That is problematic, because, as I've just stated, all of our constitutional rights are grounded in substantive due process in some way. The right to vote, as I just gave an example, the right to privacy, the right to what we call personal autonomy, the right to marry, that is grounded in substantive due process. Just about every right that you can think of is grounded in some substantive due process. And so to have a justice come out and say that they're not a strong believer in substantive due process is very disconcerting from a legal perspective, and it should be very concerning to anyone, regardless of whether you are pro-choice or pro-life. So as you can see, the Dodd opinion has grave implications for our constitutional rights and fundamental rights going forward, not to mention the shadow that it has kind of cast on the whole concept of liberty from a constitutional perspective. So be mindful of those things when we see something that seems like it sounds good, but then when we actually kind of see how the inner workings of it and how it actually works, it's not everything that it's cracked up to be. So with that being said, that's all I have to say for today. If you found this to be interesting, go ahead and hit the subscribe button so that you can receive notifications of future episodes, and I'll see you then.